comment session for the North Carolina Task Force on Racial Equity in Criminal Justice. We have a full agenda of all of our public comment slots filled up, so I want to get straight into it to hear from you. But and also, of course, I want to welcome our task force members who are present and listening. So, but first, let me turn it over to Attorney General Stein. Do you have any words of welcome you would like to make?
Just that, words of welcome. We really appreciate everyone signing up, and we're eager to hear your thoughts because we want this to be a truly effective task force. Thanks, Justice.
Yeah. Okay, so let me just explain the procedure. Ellen, you'll hear your name called as those of you who are signed up to speak, and we need you to use the raise hand feature so that she can quickly identify you and promote you to be a panelist. Everyone will come into this room muted, so you will then need to unmute yourselves, and not everyone may realize that, so bear with us as we wait for our speakers to get in with us and unmute themselves. But once you're unmuted, you'll have 2 minutes to speak. You'll see on the screen there is a timer so that we can all see the time, and because we have all our slots filled, we're going to have to be very rigorous about only 2 minutes. But let me assure you that if you run out of time and there's more you want to share with us, there is a feedback form on the website that has unlimited characters. You can enter into that form as much information as you want, and that is at ncdoj.gov/TREC, TREC. That is the site where you can give us written feedback. You can also email us if you have articles, attachments, things you would like us to review. The easiest way is to send it to a single email, and that email is criminaljustice, all one word, criminaljustice@ncdoj.gov. So if you can't get everything in the 2 minutes, there are other opportunities to continue to provide feedback. So I think at this point, I can turn it over to Ellen to call our first participant.
First up, we have Kathy Greggs of Fayetteville.
Hello, can everyone hear me?
Yes, we can hear you.
Yes, thank you for allowing me to come on. My name is Kathy Greggs. I am the co-founder and president of Fayetteville Police Accountability Community Task Force. The reason for my call this evening is because I wanted to let you know that we did send a letter to Governor Cooper on August 19th from several different nonprofit organizations. That is a statewide effort of police accountability, such as REPS, also Save My Sons from Raleigh, Emancipate North Carolina, and Advance North Carolina. The reason why I'm calling you tonight is because I want to address that we need to eliminate qualified immunity here in North Carolina. Several states has already started to actually do a police policy reform bill eliminating qualified immunity along with no chokeholds, body cam footage, and tampering with evidence. We feel that qualified immunity violates the due process of citizens. It also violates the justice of citizens. Qualified immunity grants an undefined authority of law enforcement. It also gives them the power to continue to do injustice acts against citizens. Qualified immunity costs taxpayer money in North Carolina billions of dollars that we could be spending this money to improving our livelihoods and the quality of life here in North Carolina. We would like to eliminate qualified immunity as soon as possible. We already sent the request to Governor Cooper. This letter will also be sent to you once we get off of this call. And I just want to say that we're a statewide effort, and we're happy that you guys are willing to assist us with making our North Carolina the betterment for the community and the citizens. Thank you.
Thank you.
Next up, we have Danny Elkins.
Hello.
Hello, Mr. Elkins, go ahead.
Yes. Hello, my name is Dan Elkins. While most of these concerns address the racial inequalities prior to being arrested, I just wanted to go ahead and say my concern is that of being post-arrested. My concern, we can take some immediate remedies to these problems. Unfortunately, 10 years ago, I had several occasions where I've seen firsthand of the racial inequalities, and they continue to exist today. The truth is that logic and common sense can fix the majority of these issues. It's not that that we're actually racist, but if you actually work in the courtroom, you'll understand what I'm about to tell you. Every day during first appearances in a courtroom setting, you'll see that the night before that someone's been arrested, typically you've got a quick 2-minute hearing where the judge is going to ask the individuals if you're going to hire your own attorney, if you'd like to apply for a court-appointed hearing. Sometimes there may be a quick bail reduction hearing to accompany this, but that's usually in a rare case. In most cases, you've got, statistically, the Caucasians who mostly have bonded out prior to this, have already bonded out prior to the hearing, who have shown up well-groomed and dressed, and usually semi-casual formal dress, and allowed to seat amongst the free people in the galley. If you're mostly African-American, there's a 90% chance that you were not able to bond out. Most likely you were charged with a lesser crime than that of the Caucasian male colleagues sitting in the actual galley. If you're African-American, most likely you're sitting in the cage jail cell beside the courtroom, not groomed and dressed in the actual orange jumpsuit with flip-flops on, only to be escorted out in front of the judge where your name's called, not to mention with shackles on. Folks, this is clearly racial inequality, when the actual fix is that most detention centers in the jails already have salons and barbers that can actually go ahead and actually go ahead and actually get groomed and actually get somewhat cleaned up to go to be appointed to actually be taken in front of the judge, to be actually equally groomed and properly with proper attire on before you present it before the judge, the district attorney, and possible probation officers. So you would actually look equally amongst everyone else before everyone else. So that's what I would like to tune into and let everybody be aware of today. So thank you very much for listening to me.
Thank you.
Thanks.
Next up, we have Christy Puckett-Williams of Charlotte.
Hello, everybody. Can you hear me?
Yes, we can hear you. Please go ahead.
Okay, we live in the most racially diverse democratic country in the world, and whatever gains this country has are not equally and equitably shared across society. In fact, there are whole segments of our communities that are marginalized. One fundamental aspect of this marginalization is the disparate treatment of Black and Brown folks, which occurs incrementally across the entire spectrum of our criminal legal system. Racial and ethnic disparities in the system only serve to foster public mistrust of the criminal legal system and impedes our ability to promote public safety. Racial disparity in the criminal legal system exists when the proportion of racial or ethnic groups in the carceral system is greater than the proportion of such groups in the general population. The causes of such disparity are varied and can include differing levels of law enforcement emphasis on Black and Brown communities, legislative policies that are implemented to exacerbate already existing disparities, and or decision-making by system actors who exercise broad discretion in the process at one or more stages in the system. Statistics at both the local and national levels show the cumulative impact of racial disparity through each decision point in the criminal legal system. Decisions made at one stage result in Black folks being detained before trial at greater rate than similarly situated whites. They will also be disadvantaged at trial and sentencing by having reduced access to defense counsel, community resources, and treatment options. Racial disparity challenges the basic values upon which the criminal legal system rests. To the extent that such disparity is a result of racism, it represents an outright rejection of the principle of equal justice. A commitment to values of justice, fairness, and public safety compels system actors to vigorously address disparate treatment when and where it exists. A sense that the criminal legal system is fair is essential to the functioning of a democratic society. There must be a nexus between societal values and personal values. Fairness and a commitment to due process is an absolute societal and personal dictum. Without this commitment, confidence in the rule of law erodes. For example, since the police are the gatekeepers to the criminal legal system, fundamental mistrust and suspicion of police destroys the relationship between law enforcement and the community at the most direct contact point between the public and the system. Law enforcement and system actors and agencies must publicly communicate their recognition of the fact that a racially imbalanced system will have a negative impact on families, communities, and the larger society. In order for a democratic society to function.
Ms. Williams, I'm so sorry, but your 2 minutes is
Okay.
up, but if you please submit the rest of your comments to us. Thank you.
Next up, we have Rose Poole of Cedar Grove.
Ms. Poole, have you unmuted yourself?
Can you hear me?
Now we can hear you. Thank you. Please go ahead.
Okay. My problem with the police department here are with them using CIs that are not competent, and they're using them, and I feel like they're abusing those people because most of them are alcoholics or either on drugs, and something needs to be done about that. That's my only concern is the way that they use CIs. I think they abuse those people, and that something needs to be done about that.
Okay, thank you.
Next, we have Meko McCarthy.
Mr. McCarthy, we're not hearing you. Can you unmute?
Can you hear me now?
Yes, thank you. Sorry.
Okay. Hey, okay, the reason that I'm calling in, I have a few different issues. One, I want to know when they was going into the immunity, I think they really need to really consider that law, Connor versus Graham, which allows officers to be allowed qualified immunity. That's one issue I think need to be revisited because actually police officers are considered like a private sector. They're not really government officials. They're here to protect, serve, and make sure the peace isn't breached. But only thing they have been doing now, we can see for decades, they come in and make the situation worse. And a lot of people are losing their lives at the casualties of officers. So that goes back to, I would like for, maybe Josh Stiles or either Roy Cooper to consider, Safe Coalition and Action NC's request when we ask for an independent audit in the police department. It's a lot of different various things in which we, the people as the public, and they are public servants, and we have questions about a lot of different things, the way they engage the community, and a lot of different stuff is coming out. So we do feel that there should be a independent audit, because if you look at a lot of different things from racial profiling, culture profiling, car profiling, a lot of those different things, these Trump marijuana charges that they put on, kids. I just think there need to be an audit in a lot of different things, from their mic pack, dash cams, the car cameras, their interrogations, how they interrogate. I think it needs to be an audit in how they engage the community. I think that should be something from their mic packs and body cameras. So that would be something that I would say I would love to be considered, to really consider that audit.
Wonderful. Well, thank you so much.
You're welcome.
Next, we have Alan Cressman of Morganton.
Mr. Cressman, we're not hearing you. Can you unmute? There you go.
Can you hear me now?
Yes, we can. Thank you.
I want to first thank you guys for taking the calls this evening. It's important to have a community input. I think by now we've all heard about the story of Mr. Ronnie Long here in North Carolina, who was wrongfully charged and served over 40 years in prison. I'm not a minority. I'm a white gentleman from Burke County, but I was wrongfully served not once but twice, just because I had the same name of an individual in Buncombe County. And I think I told you guys before, I had to lose a day's work and all to go to Asheville, North Carolina for something that had absolutely nothing to do with me. So it does happen. I feel like that citizens should deserve a right to recourse, whether it's the police department, the court system, whatever. We should have a voice just like the police and the courts do. If there's we all are human, mistakes happen, but it's not fair that the citizens don't have a voice when mistakes are made. Thank you, guys.
Thank you, sir.
Next, we have Johnny Thomas of Raleigh.
Can you hear me?
Yes, we can. Please go ahead.
Yes, ma'am. Ms. Justice, AG and members, mine is more of a request than it is a statement. I understand and respect all your positions in the state. But my question is, as I spoke to members in my community, a lot of us feel there's nobody that is representative of the community on this board. So I'm kind of asking how y'all at least in the process of considering having somebody from the community come on board as a board member to be involved with this, because the optics of a task force, the community has to feel that they have a voice here. And as I looked at everybody's credentials, I don't really see an advocate person on this board. I'm sure that, I know there's civil rights lawyers and all of that. Well, I mean somebody who's actually advocating, somebody who lives in the community, somebody who also has the experience or went through the experience of knowing what it's like to have an altercation with the police or to be misjudged or something like that. I'm a member of the Raleigh Police Review Board that just started up. I am not speaking on their behalf. I'm coming because I hope what we do, that y'all will even help us gain more power so that we can do even more for the community. So I would like to, hopefully y'all will have a way to get in contact with y'all so I can submit more information to you. Thank you for your time, and consider putting a member of the community, an advocate, an actual person from the community that are having these problems on the board with y'all to help better the optics. Thank you.
Thank you, sir.
Next, we have Nikita Long from Winston-Salem.
Are you able to hear me?
Yes, we can hear you.
Hey, my concern is for the limited availability of criminal records for people who have a criminal background that may be on probation or parole, and how easy it is for anybody to look up those records, which could lead to housing and employment and other discrimination for social programs. I think that those records should be limited to anybody with a legal need to see those, since it holds such sensitive information. It should be held accountable like you do a social security number or any other personal information, such as address or, birth date or anything like that. I think that information is readily available for anybody to Google. And I think that it leads to extreme prejudices and discriminations when people come out of prison, or if they are on probation and they have to live in their communities, and then, you know, citizens or law enforcement or anyone can look up their name and see that they have a past criminal record or they have a criminal history of certain behaviors that could lead to targeting and profiling and discrimination. So I think that there needs to be a system in place where those records are not so publicly accessible. I mean, even people with criminal records have legal rights, and, you know, there are people that are acquitted and there are people that, you know, sentences are reduced. And I don't think that Googling that information gives a clear picture of what is going on in the background, but it does lead a very disproportionately discriminating image that affects, you know, men and women of color predominantly. I think that it should be where someone, if they need that information, they should have to log in. That way it can be researched and recorded to see if that information is being held against that person for jobs, housing, social programs, education, and other things of that nature.
Thank you.
Thank you.
Next, we have Alan Longman of Hartnett County.
Hello, hello, can you hear me?
We can hear you. Yes, sir.
Hello, can you hear me?
Yes, Mr. Longman, we can hear you.
Okay, I want,
Well, we could.
well, what I wanted to do was explain that you were given a directive by the governor of what your scope would be when you formed the task force. Why don't you let the data that you collect from everybody determine how you should respond to get justice done and not be limited in what you do. The other thing is that I see that we talked about qualified immunity. I think the police do the harm that they do because you've given them the license to misbehave and to do things racial without any consequences. And I believe that you see this in the way that DAs can't prosecute law enforcement. They misuse grand juries so that they have so-called not enough evidence and have too much control over the grand jury, so that you can never prosecute law enforcement because of the qualified immunity and because the DAs have too much control over the process. And we believe that they should always go to court and determine whether or not there's enough evidence against law enforcement as part of due process. We also like to see people, like it was mentioned before, people like NCCU Dorm, Professor John Livingston, Dr. Claudette from the psychology department, and some people from sociology, academics on the committee talk to you about the statistics. Statistics you're looking for already exist, and they've been researching it for years.
All right, thank you very much.
All right.
Next, we have Arvis Owens of Raleigh.
Can you guys hear me?
Yes, we can hear you.
Hi, I represent North Carolinians for Rational Sex Offense Laws, and I want to thank the committee for allowing us to speak. And the theme of this brief talk is to be fair rather than to seem unfair. I want to quote to you a few stats. 22% of North Carolina are African American, but yet 37 to 40% are on the sex offender registry. Of 1,700 members who have misdemeanor sex offenses, 42% are African American. So they can't shelter at schools, but yet they could vote at schools, and they could go to a PTA conference or a parent-teacher conference. We would want them to have access. Also, COVID testing. They can't go there to get COVID testing. To be fair, rather than to seem unfair. We want there to be no registry for misdemeanors. We also want to leverage the wonderful university system. And if we're going to change laws around sex offenses, we'd like to use data that's done by that wonderful university system. And then lastly, we would like to be a part of the second chance legislation and have equal protection under that act. Again, to be fair rather than to seem unfair. That's all I have. Thank you.
Thank you, sir.
Next, we have Elaine O'Neill.
Hello.
Hello, we can hear you. There you are.
How are you, Justice Earls and my friend Judge Moore? Good to see you all, Attorney General Stein and all the committee members. Thank you for having me here tonight. I am here officially representing as chair of the Racial Equity Task Force in Durham. We had about 2 years of work. Durham City Council pulled together 17 of its citizens to study, 18 of its citizens to study this issue in a variety of areas, including the criminal justice arena. For those of you all who don't know who I am, I was a sitting judge for about 24 years in Durham, and also just finished a stint at the great North Carolina Central University School of Law as this interim dean. I know this area well, and I want to speak to you tonight very briefly on how I hope you will approach this work. This is a hard issue. It is not the recommendations that you will see from our report, I encourage you to read it. It's about 64 pages. 5 or 6 of those are devoted to criminal justice, but you have to really do your own individual work and establish the culture that you will have as a commission, as a task force, so that you can be honest about these issues. These task force are 400+ years in the making. And so I would encourage you to look at yourselves and your life and how you have been impacted or affected by racial inequity. And I guarantee you, you all have. We can fix this. This is not rocket science. It is a matter of will. And the criminal justice system has been the tool by which white supremacy has reigned. Laws dictate the morality and the culture of a society. And that is what is going on in America now. Is going to be reckoning. I encourage you to read this book, 100 Years of Lynching by Ralph Ginsberg, and you can see what the law allowed. Thank you.
Thank you.
Next, we have Kareem Haldeman.
Hello, everybody. My name is Karen Haldeman, and I served with Judge O'Neill as the vice chair of the City of Durham Racial Equity Task Force. The Durham Task Force put together, over the course of our 21 months together, safe spaces to talk about white supremacy, racism, dismantling white supremacy, and anti-racist work. And that took time. And Judge O'Neill spoke about that briefly with you today, to do some self-reflection, some group reflection, but doing the work up ahead to actually address these issues of racial inequity. It took some time, as I said, building trust with one another and creating those safe spaces in which to be very honest with one another about how we were going to approach these issues. So jumping in and getting to some nuts and bolts is one way of doing it. We recommend really doing some work up front and acknowledging the histories that were here in the first place. I'd also like to discuss how the criminal legal system intersects with other racially inequitable lived experiences. It does not exist in isolation. You will find in our report that it has intersected in our city around opportunities to build wealth, the way that we teach public history, the way we experience trauma, health and housing affordability and accessibility, healthcare and environmental justice, and our educational system. So to look at criminal legal system in isolation, it does the lived experience of people in North Carolina a disservice. So I would ask that you would look to that intersection of all of those different lived experiences when you do look at the criminal legal system. Also, listening to Mr. Thomas earlier, we say in the report that those closest to the pain should be closest to the power. And I think his recommendation to put someone from the community on this task force is a great idea. I would ask that you also look in the report about how we do recommend that you engage the community at all levels of this work. It's really important. And finally, to my white brothers and sisters, I ask you to engage in the anti-racist work as white people, and look to our report if you want to have a primer on it, and continue the work ahead, please. Thank you.
Thank you.
Next, we have Cierra Motley.
Hey, I'm Cierra Motley from Emancipate NC, as well as a fiance of a man that's currently incarcerated due to misidentification. So today I will be talking about eradicating or slowing down wrongful convictions. First, I want to throw some numbers out there. 54% of wrongful convictions are results of police and prosecutorial misconduct. 72% of wrongful convictions of homicide after exonerated was a direct result of prosecutorial misconduct. 28% mistaken identity, 24% invalid science, 59% jailhouse snitch, and 40% overturned convictions, misidentification played a role. The top 6 wrongful conviction leads are misidentification, suggestive identification, police and prosecutorial misconduct, false snitch testimony, invalid junk science, and systematic racism, failed or underfunded public defender. Some steps to slow it would be some states and counties have implemented a practice called double blind identification process. A detective who is not the lead or associated with the investigation will have a witness walk them through the identification process. Having prosecutors speak with witnesses as well as walking through the process of how they identified the person or persons in interest, changing interrogation procedures, changing informant practices, better evidence storage preservation, also implementing organizational model, allowing police departments to review errors as system-wide weakness instead of a single cause. I would also like to urge that we immediately release our loved ones due to the surge of COVID in our jails and prisons and the Department of Public Safety not having a handle on it. So I hope that you take those recommendations in consideration. I conclude my time.
Thank you very much.
Next, we have Elaine Smith.
Can you guys hear me?
Yes, we can hear you now. Please go ahead.
Okay, thank you. I am here on behalf of my son, Corey Smith. He was wrongfully convicted of attempted human trafficking and first-degree kidnapping in Durham County. This is a clear case of systematic discrimination where police officers have fabricated facts in the report and the discover and withheld evidence, which is a clear Brady violation. The prosecutor formulated facts on record and the presiding judge clearly cherry-picked what he allowed and what he decided to throw out. Mr. Smith was sentenced as a level 4 and a level 5, which was clearly wrong, and the judge ran the sentences consecutive for the same charge. In his case, a Brady violation was prevalent, as well as ineffective assistance of counsel and prosecutor misconduct. His case was totally based on false findings of an officer that was forced to resign due to an internal investigation involving police misconduct and proven cases of evidence tampering. The judge denied my son and his attorney access to the Dirty Cops file at his trials as if they were trying to keep it under wrap and allow the officer to ride off into the sunset. My son was denied his constitutional right to confront the witness, nor did the jury have a chance to weigh the credibility of said witness. Also, the witness in my son's case was declared unavailable without the state meeting the burden of establishing that the witness was constitutionally unavailable to testify. And there, again, there are several legal inequities within his case. The United States versus Kelly, where the prosecutor knowingly used a perjured testimony. Also, in another case, United States versus Arajo, the statements are inconsistent for purposes of impeachment. And lastly, State versus Jones, that was in North Carolina in 1984. We see no legitimate reason why a trial court should not continue a trial to protect a defendant's confrontations right with the same flexibility. Again, I am here, but due to the limits of time, I must stop. However, I leave you with this question. What happens to the people that don't have anybody to work on this conference the way that I am? Please have someone look into my son's case. Thank you.
Thank you.
Next, we have Entrice Moore from Greensboro.
We're not hearing you. Are you sure you're unmuted?
Yes,
There
I'm
you go.
muted. You can
There
hear
you
me?
go. We can hear you now. Thank you.
Okay, hi. I'm speaking in reference to Cortez Moore. He was arrested in 1996 and was detained, and he was taken back to the crime scene. He was only 18 years old at the time. He was taken back to the crime scene of the crime of where he committed the crime at, unwillingly taken back to the crime scene. He was taken to jail and he was charged with second degree rape and a burglary. Today he's serving a lot of time right now. He's doing maybe 25, 30 years for a home invasion. Something it's like unheard of. It's like, wow, okay. Then he did a motion. He put in a motion just to see if he can get his blood work back for 2019. Everything came back unfounded as far as the rape went. Everything was unfounded. Nothing on the woman, nothing transmitted from him to her, nothing founded. So why is he still serving 30 years in jail for a home invasion? It wasn't a simple burglary, but it was just, it wasn't simple. It would happen, but everything that they saying happened didn't happen. So he's serving 30 years plus on a burglary charge, basically. His lawyer led him to believe that, he was going to get more time. So at the age of 18, he pled out to 441 months. When it was only when it really supersedes his real time, what he's supposed to be getting, what he was supposed to be served. It affected his Sixth Amendment, his amendment's rights. That's exactly what it did. It violated his Sixth Amendment rights. I'm driving right now, so I'm sorry that I can't remember everything.
No,
But anyway,
I understand you do have a minute left.
Okay, so yeah, so what is the six was okay. So second degree sex offender, and during his hearing, like I said, he was led to believe that he was going to get more time. The judge gave him extra time because he was a black man. He said that he told him that I'm going to teach you a lesson to never do anything to another Caucasian woman again in life, and added more time to his sentence. Okay,
I think I may have misread our clock, but thank you. We've got your comments. Thank you very much.
Thank you.
Next up is Melissa Powell.
Hello, can you hear me?
Yes, we can hear you now. Please go ahead.
The felony murder rule states that you can be charged and convicted of murder, even though you never committed the murder, had no intent to commit murder, took no steps to threaten or harm a victim who was killed by a third party in the commission of an offense. In North Carolina, felony murder carries a life sentence without the possibility of parole, which is essentially the death penalty because you were sentenced to die in prison. Since the inception of this law, there has been a disparate impact in Black and Brown communities. Over 70% of those charged and convicted under this rule are Black and Brown with an average age of 19, many of whom are first-time offenders with no prior convictions. Should a nonviolent first-time offender with no prior record who killed no one be sentenced to die in prison? Criminal justice reform in North Carolina has to begin by abolishing this most unjust, archaic, exceedingly harsh and overly broad, and one of the most widely criticized principles of American criminal law. The sentencing is racist, it's applied unfairly and arbitrarily, and reveals the prosecutorial bias and racial discrimination that's in our criminal justice system. If it were applied fairly, it probably would have been abolished a long time ago, as it was in England, which is the country in which it originated, as well as other countries, Ireland, India, Canada, and most of the world have abolished this law. The United States remains the only country where the felony murder doctrine exists, and even such states do not apply it uniformly. Some states don't even have it on their books. So shame on the United States and shame on North Carolina, because these Black and brown lives do matter. Zechariah 7:9 says, "Thus says the Lord of hosts, render true judgments, show kindness and mercy to one another." True judgments, felony murder rule is not one of them. How can anyone in good conscience, be it a judge or a prosecutor or any legislative authority, punish a nonviolent offender with life in prison with no chance for parole when there are criminal statutes that govern murder and underlying felonies? So felony murder rule is nothing more than an evil that drips with systemic racism at its core to throw away the lives of many persons of color. And these Black and brown people are not disposable. Their lives do matter. So I implore each of you to take a stand for what is right.
Thank you so
and
much.
abolish this. Thank you.
Next up, we have Kareem Fitts.
Hello, can you hear me?
Yes, we can hear you. Go ahead.
Hey, good evening. I'm here with my mother, and I'm on here on behalf of my brother Rashawn Fitts. He's a North Carolina resident from Wake County, and he's currently serving a life sentence for murder. Time served as today is 2,680 days. The injustice and unfairness in Mr. Fitts' case are as such. Mr. Fitts was denied a self-defense instruction at trial, when all evidence at trial pointed to a self-defense instruction. Also, the jury at trial asked the judge, could they consider self-defense as a defense to murder? The North Carolina Court of Appeals, in their published opinion, stated, and I quote, "Although I believe Mr. Fitts feared for his life and that his actions were reasonable, he did not form a specific intent to kill." The North Carolina Court of Appeals decision in State versus Fitts is conflicting in their reasoning in State versus Ayers, stating that Ayers did not form a specific intent to kill in order to receive a self-defense instruction. And contrary to the North Carolina Supreme Court case law, State versus Richardson, dealing with the intent issue in self-defense cases. Ultimately, without giving Mr. Fitts a new trial, no justice will be served, and it will deny Mr. Fitts of his due process law right, which is constitutional and also guaranteed by the Bill of Rights. Ladies and gentlemen, a person's freedom should not be decided on whether or not they have the financial means to obtain a lawyer. Mr. Fitts has been trying to raise money for 6 years and also still trying. I just want to say in closing, he's my brother. I actually knew nothing about the law. I looked at the UNC School of Law discussion board and found his case in as it pertains to State versus Ayers. I've been trying diligently, and I'm just trying to look for some help to see how can I resolve this issue. We don't want to get him out of prison. We just want to get him a fair trial. And thank you.
Yes, thank you, sir.
Next, we have Diana Powell.
Ms. Powell, are you there? It doesn't appear that you're on mute, but we're not hearing you.
We can come back to Miss Powell. Let's try Jasmine Royal of Greenville.
Ms. Royal, can you unmute yourself? There you, we can see you. We're not hearing you though.
Let us try Mr. Robert Dawkins.
Mr. Dawkins, can you unmute yourself?
Hello, can you hear me?
Yes, we can hear you now. Thank you.
Okay, good. Thank you for giving me an opportunity to speak this evening, and thank you to the task force for addressing a pivotal moment in our nation's history. I am Robert Dawkins, the political director of Action NC. Unfortunately, in our country, the bridge of trust between law enforcement and our communities out in the street is burning. I wholeheartedly know that there are good police officers out there and African-American leaders within law enforcement who lead their departments to the best of their abilities. But each time an officer of the law shoots an unarmed Black man or profiles a Black woman, that bridge just burns more and more. You don't need to look any further than downtown Raleigh or downtown Charlotte to see how that affects our communities and our local businesses. The bridge of trust between our law enforcement, emergency services, and community has to be rebuilt. As Secretary Hooks referenced last Friday, I highly encourage the task force to invest in legislation that supports the collaboration between clinicians and law enforcement, such as allowing a solely clinician-led crisis intervention team to be the first responders to nonviolent, non-criminal incidents, so that people who may be having mental health crises can receive treatment without the threat of criminalization. We are not requesting a continuation of programs like Raleigh's Acorns or Charlotte's Crisis Intervention, but a real clinician-led response program. While this concept may seem new, our state supported similar pilot programs in the past that have been successful but not sustained, such as the Community Paramedicine Pilot Program from 2015 to 2017, and the establishment of the Crisis Intervention Training for Law Enforcement in 2005. Unfortunately, the Crisis Solutions Coalition was dissolved in our state July 23rd, 2018. Programs such as Cahoots in Eugene, Oregon, and STAR in Denver, Colorado have seen success. Help us rebuild the bridge between our emergency services and our communities to create a public safety program that works for all in our community, keeps our community safe, and gets people mental health services that are protected by HIPAA and not just forms of criminalization. Thank you so much.
Thank you.
We are going to try Diana Powell again.
Hello, can you hear me?
Yes, we can hear you.
Sorry about the technology there. My name is Diana Powell. I'm Executive Director of Justice Serve in North Carolina. Good evening, and thank you all for this opportunity. I want to speak on the behalf of being a community court advocate. Many days I've sat in the courtroom and I watched the injustice of sentencing. Too many plea deals. There must be some reform around the North Carolina plea deal system. As we know, 98% of our people who are sitting in prisons and jails, all of them guilty or not guilty. Can you imagine a person sitting in these prisons and jails knowing they lost their freedom for not receiving a fair case before the courts? Can you imagine them having to return back into society, knowing they did time away from their family and friends, knowing they were not treated fairly? The reentry process is so hard, with so many challenges and barriers before them, with limited resources. There must be a better way in North Carolina, as a North Carolina plea deal state, to do better about our people in this system. Thank you and have a blessed evening.
Thank you.
We're now going to try Miss Jasmine Royal.
Hello.
Yes, we can hear you.
Hi, how you doing?
Good.
I just want to say thank you for this opportunity in this moment and for the North Carolina Task Force. The motive at this time is to gain parity, justice, and truth throughout North Carolina and within the justice system. And I am here today on behalf of a Pitt County resident from whom has been serving 240 to 297 months for second-degree murder. And he served 137 as of today. The maximum sentence for second-degree murder is 10 to 15 years. This offense carries a maximum sentence of 481 months. And there were several iniquities discovered within this case. His prosecutor has been found guilty of prosecutorial misconduct for wrongful convictions and over-sentencing 3 people. And lawsuit was filed in January 27, 2020. It was Barnes versus Montaigne. And his lawyer did not state the mitigating factors, nor did he present evidence of a potential witness that he had interviewed in the past. The negligence and the gross sentencing of an active man that was there for his family. The newly discovered evidence with his prosecutor has just been exposed. In your review of this injustice of the conviction to ensure this overturn would be greatly appreciated, please.
Thank you.
Thank you.
Next, we have Jonathan Brown.
Hi, my name is Jonathan Brown, and I am a lawyer with North Carolina Prisoner Legal Services. And one of the things that I do as part of my responsibilities in handling cases is to look at the mental health records of my clients. I think everybody knows, or a lot of studies about the fact that there is a serious connection between, there are a lot of people that are in prison who have suffered severe mental illness. Studies have shown a high percentage of the people in prison are have suffered from those conditions. It's not that the mentally ill folks are more likely to be violent or that are more likely to commit crime. If they can get the type of mental health services that we should as a nation and as a state be able to provide, they would not be going to prison. They would not be having the type of activities or things that would have gotten into trouble. But the fact is, when I've reviewed these records, when I've seen it, seen what other people have known for a while, the fact is that poor people and minorities in this state do not get the access to mental health care and treatment that they need, that they deserve. The result of that is, what happens so often is that they get short hospitalization stays without adequate long-term treatment plans that would go ahead and make a difference in that. And so what we need to do is we need to think about mental health treatment and what we can do to make more access for that for poor and for poor people and for people of color. Studies have shown that there is bias when it comes to diagnosing persons of color, and also that we just need to do more about having universal treatment. Thank you.
Thank you.
Next, we have Kevin P.
Hello, can you hear me?
Yes, we can hear you. Go ahead.
Okay, thank you very much to the panel for having this discussion. My name is Dr. Kevin Patel. I'm an addiction medicine physician, and a lot of the times, a lot of the patients that I do deal with end up being in there because of legal issues. And even though they should have sought treatment before they even had a brush with law, it seems like they continue to come back. It's a cycle that once they're involved in the justice system, they just continue to come back over and over because they don't have the resources after they complete their substance abuse treatment to be productive members of society. A lot of times they don't have a way to get their records expunged. So employment opportunities are very few and far apart for these folks. So what they end up doing is resorting to life of crime or going back to drugs again. And it's a never-ending cycle. It seems like a lot of people are not able to hold on to the employment or not gain employment that would be helpful for them because of either felony conviction or certain drug-related conviction. And a lot of times they have to wait several years. I've had patients with DWI that lost their jobs because of it. There were no second chances. And from what I understand right now, even though DWI is a misdemeanor, it's one of the offenses that is not pardonable by the government, or there is no way to, not pardon, I'm sorry, there's no way to expunge that DWI. And a lot of these folks that are drivers or work in some sort of industry where they cannot get any work because of their criminal record. So yes, I think there needs to be some sort of reform where once they complete their treatment or go through the system, give them a second chance. And that's all I have. Thank you for your time.
Thank you.
Next, we have William James of Raleigh.
Hello, can you hear me?
Yes, we can.
Okay,
Please go
great.
ahead.
Hey, I'm Will James, first time caller, long time listener, love the show. I'm not really anybody special. I failed most of middle school. I never went to high school. I then went and I worked for IBM Supercomputing Division on DoD and NSA contracts. After that, I went to Harvard and Yale to study abstract mathematics. While I was there, I also served on the President's Advisory Committee on Race and Ethnic Harassment. One of the things that motivate my recommendations here comes from the letter from the Birmingham jail by Dr. King. He talks about genuine government in his notes of the letter in the BU library, talking about how codes and codifications must bind on the government and himself. So that's really where these come from. I think that the rules of professional conduct should apply to prosecutors. They should be expanded. The rules of professional conduct should limit private prosecutions for civil and criminal contempt. There should be special, some kind of rule adoption for that as well. Judicial caseloads are also a problem in district court. Judges really don't have a lot of time to care and be thorough. They are notorious speed readers. You could automate expunctions. Connecticut has a good set of statutes on how that's done. You could go towards e-filing. When you truly expunge something, just destroy it. Don't keep a secret file at the AOC in case there's some kind of other crime committed. expand mediation programs, pre-arrest deferrals, obviously. You could have the AOC create forms that are minimally adequate for findings, conclusions, and orders, which automatically preserve error under Rule 10, so people don't have to rely on plain error, or oftentimes you'll see judges interrupt litigants, especially pro se litigants, and even if they have the ability to preserve their argument for appeal, oftentimes when they're interrupted, it's waived. Allow people to have feedback at courthouses, magistrates, counties, lockups. Were you treated fairly? The inquiry the committee could make is, what does an institution who's actually desirous of providing notice or receiving feedback actually do?
So I have to
Okay,
interrupt you.
thank you.
That's your
I'll
2
submit the
minutes.
rest on the form. Y'all have a good one.
Thank you.
Yep.
And with that, we have passed the 7 o'clock mark. So I'm going to hand over the moderating to my co-chair. For those of you who've just joined, remember, when you get added, you have to unmute yourself.
Thank you very much, Justice Earls. Ellen, who do we get to hear from next?
Mavis Hill.
You were unmuted there for 1 second and now you're muted again. Try one more time. There we go.
Good evening. Thank you for the opportunity. My name is Mavis Hill, and I am the Executive Director of Terrell County Community Development Corporation in Terrell County. And our organization sponsors Second Chance Alliance and Reentry Program. I want to bring to your attention the lack of resources in our area, which leads to a long list of additional problems as it relates to reentry. I also want to mention the need for an active push for folk who made a mistake years ago to be given the opportunity to get their records expunged so that they are able to get better job opportunities and not continuously haunted by their criminal record. They deserve a second chance and not to continuously be punished because of this criminal record. Thank you.
Okay, thanks very much. Anything else, Ms. Hill? Thanks so much.
Next, we have Marche Clark of Greensboro.
Be sure to unmute yourself when you join us. There you are. And go ahead and unmute. There we go.
Good evening.
Hey.
I am concerned about the disparity, more of a disparity that has been, I think, created as a result of the sentencing guidelines that changed in October 1, 1994. I think it's been proven. I used to do alternative sentencing and community punishment for low risk and nonviolent offenders. And what I've seen is the sentences that are the sentences that the offenders are getting now are more punitive, particularly in the Black community, Black and Brown communities, and does not give them a lot of leeway in terms of getting back on track or having time to get back on track because they have to serve 85%. Most of them have to serve 85% of their sentences. We've been in a situation where this was disproportionate, and I don't think that it has been adequately addressed. I think it continues to penalize those who are already under all kinds of social injustices. And the only way that we're going to get something that will be punishment and rehabilitation or habilitation, because you certainly don't want to rehabilitate a person to what they were before they went in. So I'm saying habilitation, so that they will have an opportunity to move on without penalty, without continuously being judged, without being stigmatized because they have this long criminal incarceration record, in addition to having a criminal background. Thank you.
Thank you, Ms. Clark.
Next we have Ngaza Laughing House.
Peace, everybody. So thank you for the time. And I just want to start by saying that people sometimes think that racism exists in some distant land, but not here in our own cities, in our own departments. But the data says otherwise. So the data is telling us that our departments are searching 3 times as many Black drivers as they are white drivers. And the data is telling us that they arrest Black folks for the same marijuana offenses that they ignore in white communities. And that data is telling us that police use every type of force against Black folks more than anybody else. Now, despite knowing this data, law enforcement often tells us that they just need more training. They need more funding for more training, even though they've had training, yet these problems continue to exist. So we know that training is not enough. And banning chokeholds is good, but that's not enough. And the duty to intervene is good, but that's common sense. And if it's just a few bad apples anyway, then the good ones should already be intervening. And the fact is, if the good cops are out here, they should be stepping up to resolve these issues before people have to get into the streets and protest and get pepper sprayed and shot with rubber bullets and ambushed like they did in Charlotte. So I'm willing to accept that most cops are good people, but despite their existence, if the system of policing continues to operate in this manner, then what does that say about policing in North Carolina and in America? Now, everybody on this task force needs to ask yourself, if this was 1960 instead of 2020, and instead of Black Lives Matter, it was Dr. King and SCLC protesting the same things in the streets, which side would you be on? Because if you say Dr. King's side, then you need to prove it by doing something meaningful with this task force. So we need review boards that have the power to investigate and subpoena officers. We need investments in social care instead of social control. And I'm not talking about 5 social workers working for a department like in Chapel Hill. I mean real investments, reallocate money from these multi-million police budgets and putting it in housing and jobs and healthcare. Because the fact is, if we care about public safety, we have to acknowledge that you're not safe if you don't have a house to sleep in at night. And you're not safe if you're battling a drug addiction that you can't overcome. And you're not safe if, despite working 40 hours a week, you and the people around you in your community still can't afford to live and meet your basic needs in the city that we're at, despite all this money.
I want to thank you very much for your comments. If you have additional things you'd like us to know, you can please submit them by writing, but we just have to make sure that the next people get a chance as well. Thanks so much.
Next, we have Kelsey Williams of Raleigh.
There you go. There you go, Ms. Williams.
Thank you so much for allowing me this time to speak with you. My name is Kelsey Williams, and I'm a third-year law student at UNC working this semester in the Youth Justice Clinic. The topic I'm interested in presenting to you is raising the minimum age of juvenile court jurisdiction in our state. Currently in North Carolina, that is 6 years old, which is the lowest in our nation. This week, I reviewed some research that was conducted by last year's UNC Law Clinic students. In North Carolina law and history, they were unable to find an explicit reason for allowing 6 to 9-year-olds to be subject to a delinquency proceeding. Though children as young as 6 have rarely been prosecuted as delinquents, giving the juvenile court's jurisdiction over these children still allows for such a case to become a possibility. This is a huge issue for our state. First of all, children under 10 cannot be detained, photographed, or even fingerprinted, yet they can be taken to court and prosecuted for an act that they most likely cannot even begin to comprehend. According to Piaget's stages of development, a child as young as 6 still does not understand the concept of cause and effect. Therefore, though they may know what they are doing and plan to do it, they do not understand the repercussions of their choices and actions. The American Psychological Association describes the mental and social skills of a child aged 6 to 10 as very simple and basic. They get the general concepts of right and wrong, but they may not understand the results of good or bad behavior. To them, everything is just what it is. According to Erik Erikson's 8 psychosocial stages, a child between 5 and 12 is learning who they are and what they are capable of. If we as a society label them as delinquent and a problem child before they are even able to understand what delinquency is, then we're forcing an identity on them they do not even have the opportunity to choose, and it could be on their record for the rest of their life. These impacts, coupled with the already disproportionate racial treatments and statistics that affect young Black children in our state, threaten to send these children in a downward spiral away from their true potential, and it will have been our state that failed them. Thank you for your time.
Thank you.
Next, we have Kenneth Rose.
Hi, can you hear me?
Very well, Ken. How are you?
I'm doing well, thank you. I came to North Carolina as a capital defense attorney in 1990 after practicing in Mississippi for 5 years. In Mississippi, the district attorney of the largest county in the state had proclaimed that he tried to get rid of as many Black persons as he could from serving on capital juries because Black persons had less of a stake in society than whites. In North Carolina, the response was different, and the courts led by Chief Justices Exum and Frye attempted to address racial discrimination in capital cases. But instead of confronting racism directly by condemning discrimination in jury selection and sentencing, they adopted a rule restricting prosecutorial discretion. North Carolina became the first and only state where prosecutors could not offer plea bargains in first-degree murder cases with evidence of a single aggravating circumstance, and prosecutors could not consider individual facts or circumstances of the crime or the defendant in deciding whether to seek the death penalty. The results were disastrous. North Carolina became the second highest per capita death sentencing state in the country during the mid and late 1990s. Many people were sentenced to death who would not have received death sentences in other states. The limitations on prosecutorial discretion exacerbated rather than cured racial discrimination. Finally, in 2001, the North Carolina legislature mercifully ended our experiment with a quasi-mandatory death sentencing scheme. But the legacy of that tragic experiment remains. 43 people were executed under that scheme, and over 2/3 of North Carolina's current death row was sentenced before 2001. Study after study has shown that race discrimination permeates North Carolina's death penalty to this day. Our efforts to tinker with the machinery of death have failed. Innocent people, including my client, Henry McCullum, have been harmed or killed because of it. Now is the time to end the death penalty. Thank you.
Thank you for your comments.
Next, we have Tabitha Curry-Bay.
Welcome. Unmute yourself and look forward to hearing your comments. You're still muted, Ms. Curry. There we go.
Okay, thank you so much for allowing me to speak. After so many decades, the last few years, laws has been either changed or created to help nonviolent offenders get out of prison early, and programs were developed in order to rehabilitate them and re-enter them back into society. Governor Cooper and the North Carolina lawmakers, my question to you is, when are you going to start helping the violent offenders who have been harshly and unfairly sentenced under the structured sentence law? The structured sentence law has been around since 1994. That's 25 years, and it has forced offenders to complete at least 85% of their sentence. We say that we are a Christian country, a state built on second chances. Where is the second chance for violent offenders? It's time to take away the 85% structured census law. It's time to help those who are labeled valid offenders, who have been rehabilitated after serving 20, 30, 40 years in prison. After so many decades in prison, there is no more justice left for the justice system. When is enough enough? When does rehabilitation turn into inhumanity? When does justice turn into mercy? When are you going to start giving valid offenders a second chance? It's time for North Carolina to bring Black families back together again. It's time to forgive and to help violent offenders just like we do the non-violent offenders. Thank you, thank you, thank you so much for allowing me to speak.
Thank you, Ms. Krubeck.
Next, we have Lauren Miller.
Welcome, Ms. Miller.
Good evening. I'm Lauren Miller, and I'm an attorney at North Carolina Prisoner Legal Services. I've seen through my work how racial bias, both explicit and implicit, affects prosecutorial decision-making. Studies show that the greater discretion that someone is allowed in making a decision, the more room there is for explicit and implicit bias to affect their decision-making. I'm specifically concerned about a prosecutor's decision to charge someone as a violent habitual felon, requiring a mandatory life without parole sentence. The numbers suggest that a person's race can affect a prosecutor's decision of whether to charge someone as a violent habitual felon, whether to offer a plea to something less, and the terms of any plea offer. The numbers show that violent habitual felon status has been disproportionately applied against people of color at a shocking rate. One of my colleagues ran a report through the OPUS system on people who have been convicted under violent habitual felon status. It is rarely used, but the numbers show that it is overwhelmingly used against people of color. We found that 61 people have been convicted as violent habitual felons. Overall, 82% of those people were Black, about 15% were white, and about 3% were Native American. The task force should require data to be tracked that would help hold prosecutors accountable, such as the race of a defendant and whether he or she is eligible to be prosecuted as a violent habitual felon, whether a plea offer was made, and the terms of any offer. There can be systems and processes that can be put in place to limit the effects of racial bias on decision-making in our system. I implore the task force to recommend implementation of data tracking requirements and processes so that the violent habitual felon status cannot be used disproportionately against people of color. Further looking into the counties around the state where people have been convicted, we found that overwhelmingly white counties still have people of color who've been convicted as violent habitual felon. I thank you for your time and consideration, and I appreciate your hard work on this task force.
Next, we have Joseph Scott.
Welcome. If you can unmute yourself, Mr. Scott.
Okay, we're good. Thank you. Thank you all. I thank you for lending an ear for me this evening. I appreciate the varied perspectives that you all have on the task force. My subject is surveillance of substance abuse and mental illness is related to the sentencing, incarceration, and reentry, and how substance abuse and mental illness has become criminalized. For a long time, drug use has sort of shaped the criminal justice system. Drugs and drugs-related offenses are the most common crimes in nearly every community that we're in. I'm a member of the North Carolina Second Chance Alliance, and we address the causes of criminal records and the barriers they create for successful reentry. We get into, in reference to mass incarceration, racial disparities, collateral consequences, and recidivism. It all comes under the tree of substance abuse and mental health. There is a desperate cry to come from perhaps the adversarial type of system that we have in our legal system to perhaps a mental or way of medical treatment rather than incarceration for substance abuse as well as mental illness. Also, my concern is, has the task force perhaps lend an ear in reference to drug court process rather than the adversarial process that I had just recently spoke of.
Thank you very much, Mr. Scott.
Next, we have Jonathan Patton.
Welcome, Mr. Patton. Unmute yourself. Look forward to hearing your comments.
Hi, can everyone hear me? My name is Jonathan Patton, and I'm an attorney in Raleigh, North Carolina at the North Carolina Justice Center. The particular issue I would like to raise before this task force concerns the prison conditions of North Carolina prisons generally, and specifically within this COVID-19 pandemic. I believe it is well within the scope of this task force to address this specific issue, given the task force's mission of developing and implementing solutions that will eliminate disparate outcomes in the criminal justice system for communities of color. This includes people who are criminally justice involved by way of incarceration. Currently in North Carolina, people of color make up 37.3% of the state population. However, people of color are also 59.7% of the current prison population. This is a direct result of over-policing in communities of color and disproportionate incarceration in these communities, which we have heard countless times tonight. In my work, we have collected many letters from people who are currently incarcerated about the conditions that they are facing. This includes stories of being given only one disposable mask to use for extended periods of time, such as a week or more, isolation in a cell alone in a mask for 23 hours a day, crowded dormitories with bunk beds placed closely together, and a lack of transparency regarding testing and the coronavirus overall. Each of us is more than the worst thing we have ever done. We must not forget about people because they are imprisoned. Their humanity requests us to improve the treatment and conditions of people currently incarcerated as we move towards becoming a community that focuses less on harsh punishment and more on alternative forms of justice and harm reduction. Thank you for your time.
Thank you, Mr. Patton.
Next, we have Talina Massey.
Welcome, Ms. Massey. Please unmute.
Good evening. Can you hear me?
Very well. Thank you.
Good evening, task force. My name is Talina Massey. I am the president of the Young Urban Professionals of Eastern North Carolina and a close colleague and community co-facilitator of Alderwoman Jamisha Harris out of New Bern, North Carolina. America is beginning to realize that issues of diversity, equity, and inclusion are present across every sector and at every level of organizations, businesses, and government. With the task force mandate being to develop evidence-informed strategies and equitable policy solutions, wouldn't the creation of diversity and compliance officers who are responsible for the oversight and implementation of that mandate, armed with actual compliance incentives and non-compliance consequences help, especially in rural areas and small towns, often forgot about in the larger conversations of equity and inclusion policy reform. I personally believe that these diversity officers can not only assist with law enforcement training, community policing efforts, and recruiting and retaining a diverse workforce, but could potentially even be extended and delegated out to assist with economic inclusion and city and state contract compliance, monitoring and MBE certification, and a multitude of other facets that marginalized communities deal with. I hope that you guys can consider this idea, and I appreciate everything that your task force has set out to accomplish. Thank you guys so much.
Thank you very much, Ms. Massey.
Next, we have Angela Colon.
Welcome, Ms. Colon. You're on mute.
Unmuting.
There you go. We can hear you.
Is it all good? Hold on one second. It kind of dropped everything I was saying. Good afternoon.
Now we can see you.
Okay. The very Institute of Justice tells us that spanning from 2015 to 2017 in North Carolina, Black people made up 23% of state residents, but 48% of people in jail and 52% of people in prison. Further, according to the ACLU, North Carolina's Black per capita adult imprisonment rate was 4.5 times higher than its white rate. These sources also go on to describe how in courts, Black people are more likely to be detained pre-trial, have higher bonds, and receive stricter sentencing. What would you call someone who routinely harasses, harms, maligns, and kills individuals unjustly, based very much on the irrational whims of prejudice? A criminal. How ironic then that the very system whose purpose lies in combating these practices is itself one of the lead perpetrators of such crime. Our criminal justice system stands guilty of committing substantial harm to the Black and POC community and needs to account for this. Mind you, if we approach this guilt with the system's own existing culture of punishment and recidivism, it can only result in the same dead ends and stalemates as related conversations regarding reform and versus abolition have ended in. Instead, I posit that a more effective solution is to consider tools such as restorative justice holistically, so that the very system itself is held to a standard favoring restitution, not retribution. So what does this look like? Like the legitimate rehabilitation of those affected, particularly those wrongfully harmed, by directly guiding them through community reentry programs and partnerships, like the honest acknowledgement of social frustration through truth-seeking and authentic apologies to our communities through significant action versus lip service, the guarantee of non-reoccurrence of these injustices with enforceable consequences if that guarantee is broken, and qualified immunity and Brady Giglio. Now, if you're wondering where to start incentivizing statewide quotas for requirements for use of restorative or preventative programs such as the Cure Violence Global Initiative would bring healing to affected communities. This would be an admittedly small step towards reconciliation, but a start nonetheless. There's a term used when state and government programs practice restoring damages and dignity to a population it has treated unjustly. That word is reparation. Given its direct and undeniably negative effect on minority communities, the criminal justice system can and must be a part of the reparation conversation and ensure that, in fact, reparations, restitutions, and restoration are the only sustainable forms of crime response moving forward.
Thank you very much, Ms. Cohen.
Thank you.
If you have anything else to add, sorry to cut you off, just feel free to submit.
Next, we have Elizabeth Crudup of Hardin County.
Welcome, Ms. Crudup. You can unmute and address us.
Can you hear me now?
You can, thank you.
Hi, just wanted to say real quick, we wanted to acknowledge that Josh Stein signed the papers that ended the tragedy of Ronnie Long's incarceration. We're so glad that he was able to show us that it is that easy to correct the mistakes of wrongful incarceration. In case he ran out of pens, I have more, because there are many more people who need to come home. I have included in the comments section the names of 3, Shannon Yamudi, and Shannon Yamudi, Steve Harper. Steve Harper is illiterate. There's no way he could understand what was being handed back in the 80s. He is illiterate. He cannot fill out the forms for, to be pardoned. He can't fill out anything. He cannot read. But for the rest of his life, he's in prison because he is illiterate. That is not fair. We have David Green, whose girlfriend set him up in there, and everybody knows that he didn't do it, but because Lord knows what the processing is, he cannot come out. I have put links to what happened to Shannon Yamudi right there in the question and answer section. Feel free to read it at your leisure. And that signing of Ronnie Long to come home was fantastic. But please, don't stop there. Don't stop there. Let that be a start. Send home Shannon, send home Mr. Green, send home Steve Harper, send home all the names you've heard today. They are suffering just as badly. May not be as long, but it's still just as wrong. You run out of pens, I got some, we'll get it done. Also wanted to say that releasing violent people considered violent, quote unquote, actually is better than releasing non-violent people, because it has been shown that those who are convicted of violent crimes are less likely to have to recede back into that violent act again.
than those who are released for committing non-violent crimes. Petty theft is repeatable. Many of the violent acts are not repeatable. Thank you.
Thank you very much, Ms. Crudup.
Next, we have Rebecca Mayer.
Welcome, Ms. Mayer.
Hi, can you all hear me?
We can.
Hi, thank you. So I want to comment on law enforcement's use of force and the training surrounding it. I'm in a pseudo law enforcement position, and I have personally participated in a use of force training. So I recognize that there are situations where using a gun is a split-second decision. However, as recent incidents locally to our state and throughout the country have shown, it appears the default, especially when interacting with the Black community, is to reach for the gun. In many of these instances, police approach with their hands on the weapon, if not with the weapon already drawn, and there is no reasonable basis to fear for their lives because there's no immediate threat. In fact, many times the alleged suspect who is causing an officer to fear for their life is trying to disengage with the officer. I did a quick search on Durham's website, and I could not locate DPD's use of force policy, if one exists. In order to hold our law enforcement more accountable, it is important for use of force policies throughout the state to be readily available to the public. The use of force policy should be easy to find, and it should not require a FOIA request to get this information. In addition, the task force's baseline approach for the use of force policy should also outline steps to be taken before an officer uses a gun or engages in other lethal tactics. Use of deadly force must be an absolute last resort. In that vein, the state could require more training for law enforcement. Officers should be required to do an annual hands-on simulated training on use of force. This training should be teaching officers how to disarm an individual when an officer believes his or her life is in danger with tactics other than using a gun or other deadly force. It is my understanding that a taser is supposed to serve this purpose, yet it seems that law enforcement much more quickly reaches for their guns than a taser. And again, use of guns should be an absolute last resort, and even then, training should teach officers how to shoot to disarm, for example, by shooting in the leg, rather than kill. Relatedly, regular inherent bias training could be beneficial. This training should be required every 6 months so that officers must regularly confront their implicit biases and learn how to combat them. For example, officers should be taught not to approach every Black suspect with their hands on their gun or with their gun drawn, and regularly needing to engage in these conversations would hopefully produce better results. Thank you for your time.
Thanks very much.
Next, we have Natasha Davis.
Welcome, Ms. Davis. You're going to mute yourself and speak.
Thank you.
Thank you.
I'm Natasha Davis in Wilmington, North Carolina, and I have been working with the Second Chance Alliance and other criminal justice reform agencies. I'm here tonight to talk about the treatment of those that are housed in our correctional institutions. I have been watching the Senate and House committees on prison and safety and those things. And one of the things that I have noticed and that has actually really bothered me is that in all of these safety meetings, the talk is around training correctional officers on how to engage, how to protect themselves, what extra equipment can we get. Has been no talk about, are we training in de-escalation techniques? Are we training to do things other than engage? The other thing that has been bothering to me, I have read nearly the entire policy and procedure manual for DPS, which I can tell you is a riveting summer read. And there's very little external accountability that's mentioned in there. We all know that what's measured is what's monitored. And so I encourage this group to start first with auditing how people are adhering to the policies and procedures that are in the manual, how infractions are if they're being given correctly, if due process is being given, and also if the sanctions are in line with what those policies are. I can tell you from the 2 individuals that I know that are in prison, after reviewing that handbook, those absolutely are not being done. So I encourage you to work with university faculty in this state that does research, give them access to the data so they can pull this research and give it to this group so you can use it for better decisions. The other last thing I want to say is we cannot treat people in prisons like animals or less than animals and expect for them to come out with humanity and empathy and be able to function in society. If you treat them like they don't matter, they're going to treat everyone when they get out like they don't matter, because that's how they've been treated. And I have seen firsthand how families and inmates are treated that way.
Thank you very much.
Next, we have Rebecca Tremmel.
Hello, Ms. Trammell. You can unmute.
It lost me for a second. Can you hear me now?
We sure can.
Okay, great. So I greatly appreciate the courageous service of I greatly appreciate the service of selfless men and women who choose to serve and protect and promise to be there for their neighbors in their true hour of need. I'm greatly concerned that there are many who misunderstand their mission. And I wonder why some feel so emboldened to use hate speech and aggression. Yesterday, I watched as, it was a protest and there were some kids that were just acting silly. Well, one of them was arrested only because he kind of was mocking the police. That's not really a crime. It's irritating, but it's not a crime, But now he is in the criminal justice system. We have to address the culture of the police department. And I don't think we're here tonight because of a few bad apples. We're here because of a toxic culture that corrupts good people. And I believe that there are a few things that can impact the culture. I think we need to have police officers who understand their mission and that it's to serve and protect. We need to secondarily increase accountability, which means ending qualified immunity, having criminal citizens review boards with subpoena power, and mandatory data collections on use of force stratified by racial data. That has to be turned in to the FBI or the North Carolina DOJ. We need to have an investment in police, not in militarization, but in human resources, and better selection because of a better opportunity and that our officers are better supported. Also, I would like to see a more interdisciplinary approach to public safety. And as the gentleman suggested before, clinician-led de-escalation when there is not a criminal offense going on. We need more social workers in our schools, not more SROs. We must have greater accountability. And by ending qualified immunity, we ensure that no one is above the law, least of all those who are responsible to uphold it. We need to talk about better citizen review boards with subpoena power. Since 2013, the Charlotte-Mecklenburg Criminal Review Board has heard 20.
I'm sorry to interrupt. If you have additional comments in writing, please send them through the online link that we have here.
Thank you.
Thanks for your time.
Next, we have Adrian Kennedy.
Welcome. If you can unmute.
Oh, okay, great. Can you hear me?
Yeah, Ms. Kennedy, thank you.
Thank you all. In listening to the previous comments, I can only address what I have learned on my journey at Fayetteville State University in the Criminal Justice Department. Most, if not all of the isms of the system are based on our current American system and belief of crime and criminal justice. But an example of the difference in practice is implementation of intentional living and lifestyle of what I know and what I practice as restorative justice in the community. Yes, Blacks have been disproportionately affected and affected across the board, but so have Hispanics, so have Haitian Americans, so have poor whites. So have Native Americans. And so the system is spreading and seeping into an economic level as well. I think we should be looking at repairing the harm and not just focusing on the crime and the criminal, but all should be involved in the justice process. This is currently in contrast to the methods of justice, which we tend to focus on punishment and retribution. Restorative justice is practiced in other countries, and those countries have less rates of brutality, wrongful death, and correctional costs. Studies have shown that in many countries, 85% of restorative justice participants were satisfied, they were healed, they were whole again. And so I contend that we start to practice the other form of crime and justice for the prosperity of criminal justice. And it starts in the community, not at the jailhouse, not leading to the courthouse. I think that the leaders of the task force are doing an excellent job. And I say to you, this is not a far-fetched practice, that we just have to put this in practice in theory of the definition, the true definition of justice, which is love and respect. Thank you for your time.
Thank you for your comments, Ms. Kennedy.
Next, we will have Katrina Hayes.
Welcome, Ms. Hayes.
Hello, good evening. On February 17, 2016, Attorney Robert Ekstrand signed an agreement to represent my son in a special education case. He signed it as RAT, R-A-T, which is an animal. There's a street definition for rat, but this is not the time for me to expound on that. On February 22nd, 2016, attorneys James Middlebrooks and Robert Ekstrand were involved in a plot to have a judge who was out of jurisdiction preside over a special education case. The order of reassignment was forged to look like the chief administrative law judge's signature. I encourage you to pull this information up. My knowledge of this and my unwillingness to stop speaking up about this has led to a string of retaliatory acts. The last call I informed you about an anonymous caller who filed a CPS report. I have to have supervised visit with my son or have him at a family member's house. An investigation is supposed to last 45 days. It's been 50 days. The workers Jamie Coleman and Stacy Craven are dragging their feet on the process. I'm being told the anonymous report was based on unfounded court claims and my medical advocacy because I dared to be informed and request CT scans after my son had several accidents at school. There's no training for this that can fix unprofessional, biased, regressive, and illogical acts. It is time for someone to step up and do something about this. Thank you for your time.
Thank you. Ellen, any other folks?
No, that was our final speaker for the evening.
Okay, well, that's wonderful. I'll say a brief word and then Justice Earls hand it off to you. I just want to thank everybody for taking their time, most importantly, the speakers for sharing their perspectives on the criminal justice system and ideas that they have that the task force should consider as we try to improve it so that we can get rid of the racial inequities and disparities. And so first and foremost, I want to thank all the North Carolinians who shared their wisdom. I also want to thank the task force, and a number of the speakers acknowledged the task force and the amount of time they're putting into this work. I just want to say it to you all. I mean, you all are spending hours a week on this most important task, in addition to your very important day jobs. And so let me thank each of you for that. And then, of course, I want to thank the staff who is spending more time than we are to make sure that this is going very well. So Justice Earls, any final words for us before we sign off?
Yes, thank you so much. I just want to, in case there are people still listening that weren't on at the very beginning. I want to assure people that there are other ways to either supplement. We got some great data in these comments to either email us or give us comments in writing. So the ncdoj.gov/TREC, TREC, is the central site for the entire task force. And you'll also find there all of recordings of all of our meetings, all the materials that we have, as well as your opportunity to submit to us. So that is truly an enormous source of information about what we're doing. I just want to conclude by thanking everyone who participated and gave us comments. And the format is a little hard because we can't respond, but I assure you that we are hearing your comments, taking them into account. They are extremely helpful. And this truly is crucial to, this is one piece of the way we are getting community input, but it's a very crucial part. And so I thank you for taking your time this evening. And of course, thank all of the task force members for being here with us. So that concludes this public hearing. Thank you.